I'm Rick Albert, and welcome to The Key to the City of Angels, the podcast where we unlock the secrets of Los Angeles real estate. With over 300 real estate deals under my belt, I've seen it all, from house hacking strategies that build wealth to helping clients close multi-million-dollar deals in one of the most competitive markets in the world. Every week, I'll bring you expert insights, market trends, and inspiring success stories to help you navigate the LA real estate scene. Whether you're a first-time buyer, an investor, or just curious about what it takes to thrive in the City of Angels, this podcast is your guide to making smarter decisions and achieving your goals. So grab your keys. It's time to unlock your path to prosperity in Los Angeles real estate. Hello, everyone. Rick Albert here, the host of The Key to the City of Angels. Are you world famous, Leo? Leo Rotenberg, are you world famous?
At least in Encino.
Okay,
let's say Encino.
Okay, we'll say the Encino famous Leo Rotenberg, attorney at law. Well, we're going to go over some of the latest rental laws, things like that. So, Leo, I'm going to let you kind of take the lead, and I really appreciate it. I'll jump in with questions if I have anything.
Absolutely, Rick. Okay, I appreciate it. Yeah, so the last time I had a webinar with you guys, it was around the time where the COVID protections were expiring. And of course, our city council has decided, to try to along the protections as long as possible, just call it a different name. So here's what we basically have in that regard. Well, I have to say this is not legal advice. This is just very general. It's intended just to give you it's information, overall information about what's going on. If you do want legal advice, please call my office or email me, and then my office will definitely help you out. So as an overview, what I'm going to discuss, it applies to LA City. There might be other laws, that are local to the county of Los Angeles. It's the unincorporated Los Angeles County, or the state of California, or any of the other localities, in California that may be specific to those localities. So I'm going to give you guys a couple of important updates that I've seen. These aren't all of them, of course, but the ones that I've seen and the one that I've encountered with clients ever since the COVID protections expired. I'm going to go over a little bit about the difference between RSO properties and JCO properties. RSO is a Rent Stabilization Ordinance. The JCO is the Just Cause for Eviction Ordinance, which was passed after the COVID protections had expired in LA City. That basically applies to all of the non-RSO properties. I'm going to go over a little bit very briefly about the price gouging laws post-fires. Right? As you know, the fires have affected a lot of the properties. It hasn't affected all the properties, although there is an emergency order right now that makes basically ice gouging illegal in California. So you really have to be careful about the prices that you list your properties for if they're vacant, and about the rents that you're increasing to if they're occupied right now. And then I want to really go over this hot topic about habitability lawsuits. This is it's becoming a lot more popular these days. I really want to go over that and discuss the steps that you should probably take. So if you do encounter a lawsuit like this, it will not as a complete shock, because these are happening more and more. That's what I'm seeing. So back to the 4 questions that I usually ask, when a client calls me. I ask them where the real estate's located, where the property is located. And the reason why I ask the question again, I want to know if the local ordinances apply, because they may be specific to the location. Is it an LA City? Is it an unincorporated LA County? So I have to know, because I have to know which laws are applying. I have to know the year the property is built, because even if I know the locality of where it is, what laws apply depend on when the property was built. Okay, this has to do with kind of rent stabilization ordinances. What type of property it is. A lot of times, the reason I ask this question is that the type of property will dictate kind of if the rent ordinances apply or not. Is a tenancy early month to month or not? A reason that I ask this is if you're in a term tenancy, like let's say it's a year term, you technically can't change the terms of those tenancy mid-term. But if you're month to month, you can with of course a lot of exceptions. We can get into that. I did make this decision, the last time that I had a webinar with you guys, basically the difference between the county of LA and the city of LA. If you look at map, obviously the LA County is a huge area of land. it has a lot of cities within that county. And one of those cities is LA City. Right. Okay. You have other cities there as well that have their own ordinances, they might want to look into. But the laws in LA County, okay, when you go on the LA County kind of website, they will tell you which laws apply. And generally, these laws, they're specific to unincorporated LA County. You have some areas, okay, within the county of LA that are not incorporated into any specific city, right? They're just kind of areas. And that's what we call unincorporated LA County. And they have their own laws, which we're not going to be going specifically into, but I want to make sure that you guys are aware of this distinction. I want to quickly go over the RSO again. It basically applies to all properties and condos, multi-unit properties that were built before October 1st of 1978. Single-family homes are exempt. However, you guys need to really understand that they're exempt from the LARSO. But what's really important that when you have a property like a condo or a house that's exempt from LARSO, and you also know in your mind, because of Costa-Hawkins, it's also exempt from the California TPA, right? Okay, the Tenant Protection Act. It's not automatically exempt. And I want to make this very clear to you guys that in order for it to legally be exempt from the TPA, from the California Tenant Protection Act, you guys need to serve the tenant with a notice of exemption. This is very important because if you don't, then regardless of all the exemptions that may apply at the city level, you're not going to get that state exemption. And it's a loophole that a tenant's attorney, okay, an eviction might be able to catch you on. So I strongly urge you guys that when you're handing a tenant a new lease, if it's a new tenancy, make sure that you give them the notice of exemption. Okay, the real estate agents are going to know about this because it's a car form. It usually comes prepackaged in a lease package. And make sure that the box is checked on that form. Because I've seen real estate agents, they'll say, oh yeah, we gave them the form. I said, but you didn't check the box of exemption, which was the whole point. It's very important that you make that. And of course, there are two main categories of a rent, the RSO, right? There's a rent increase limits, okay, which dictate the percentage of rent increases that you can make every year. And then there are just cause eviction protections, right? These are two distinctly different things, and we'll dive into those again. So lately, post-COVID, I mean, here's what the looks like. Okay, as you guys know, when and you had the moratorium, you couldn't increase at all. Up to June of last year was 4%, and up through June of this year, it's also going to be 4% annually. Now, the LA RSO, the just cause eviction regions have stayed the same. Okay, for the most part, obviously the main one is non-payment of rent. Okay, that's the one that when a client comes to me and they tell me, okay, I want to evict my tenant, he's doing a bunch of things wrong, what's the best way to go? I say the simplest way to go is obviously non-payment of rent. And the reason that I say that is because in court, it's a lot more straightforward with evidence to prove that a tenant has not paid rent, than it is, let's say, if he's committed a nuisance or if he has an unauthorized occupant. Because there it's very evidence heavy. You need witnesses. So it's a lot more complicated. And so that's why I say, if you have a tenant who hasn't paid rent, I'd go with that. You have the unreasonable interference with the comfort, safety, and enjoyment of other tenants. This usually applies to multi-unit buildings where you have neighbors that are interfering with other neighbors' kind of enjoyment of the property. This is obviously more rare. If you're using your rental unit for an illegal purpose, this applies to a lot of the times if you're doing drugs or things of that nature. Again, it's more rare. This one is more rare, and I haven't seen a tenant actually be evicted on this, and I try to stay away from this, but just so you guys know, if a 1-year lease term is expiring, then it automatically basically becomes month to month if you're an RSO property. But if you offer the tenant another year lease renewal and the tenant declines that, a lot of the times this will happen if they're on the fence. If they don't know, I don't know if I want to be here for another year. I don't know if I want to commit to another year. I'm thinking I might move in a couple months. I don't want to commit. But by not committing, that tenant could be evicted for that decision. As long as the lease agreement terms that you give them are close to the terms that they already have. So what's not similar, for example, if you had a parking space in the first year, and then you offer him a lease without a parking space, that would not be considered the same for this reason. To refuse access, it's common. This happens a lot, but I still don't like cases for the denial of access because, again, you need witnesses. The tenants could have basically reasons for denying access. They could say they were sick. A lot of ways the tenants could either get out of it or make it a little bit more gray area for a jury, let's say. So I don't like this, but again, it is a reason that's there. At the end of the term, it's not the tenant that you initially, it's leased to. Obviously, this happens a lot. That's another reason that you can get into. A tenant refused to move, even though the landlord did everything that they were supposed to do according to the THP. This is a little bit more rare, but the THP comes in if you have to do renovations that require the tenant to move out. And these are, this isn't a remodel, right? These are renovations that are necessary to do, right? So if there's major leaks in the building, you need to replace the drywall because there might be mold. If there's asbestos that needs to be abated, things of that nature that are necessary, then, then these are one of the things that you apply to the city. And this is kind of the basis for an entirely different webinar, but basically you apply to the city and you get the application for the THP. The city grants it, and the tenant has to cooperate. Oh, if they refuse to cooperate, then it can be evicted on those grounds. So, those are at-fault reasons, right? That's when the tenant has done something wrong. If you're talking about no-fault reasons, the most common one is an owner move-in. It's an owner, it's a manager, right? Okay, it's a family member. And those have gotten a little bit more strict. So, for example, under California law, which would apply to LA law because it's more protective, if you're going to do the owner move-in, you have to state the names of the people who are moving in, who intend to move in. You have to state the relationship to the owner. So the last kind of few ones that I did, kind of the notices, that I did, I had to state every name of every intended occupant. And then I also had to state a relationship to the owner. You also have to state, you have to give the tenant notice. They have the right to ask you for more proof as to the relationship of these people to you. I haven't actually encountered a tenant that's asking for proof, but just so you have an idea of what that could be, I can't even imagine what that would be, honestly. Because I can't imagine that you want to give a birth certificate or anything like that nature. It's confidential, but the law now allows this, for non-public records be published. Obviously, Ellis Act evictions, 120-day notice. If the tenant is elderly or disabled, then they can opt out for 1 year's notice. And Ellis Act, you're just removing the property from the rental market. It's not the most ideal or an investment property. Okay, the landlord would want to sell, let's say, because the problem is these restrictions, okay, they run with the land. And so what that means, if you sell the property, the new buyer, right, that owner, he has to abide by the restrictions of the Ellis Act, which there are a lot of restrictions, which I'm not going to go specifically into right now, but they have to do with the fact that you cannot re-rent the property unless you follow restrictions. Okay, for example, there's one restriction where if you re-rent it within 2 years, you're still going to be RSO. For example, that's one is a restriction that is a disincentive for people to do this Ellis Act process. And this is very common. Okay, so if you have an illegal unit and the tenant basically they call the Department of Building and Safety. Department of Building and Safety comes in and they say the tenant can't be here, and you have to convert this back into what it was. Okay, let's say it was a garage. Now you owe that tenant, okay, relocation assistance, and they have to get evicted. But it's a no-fault eviction case. So you don't necessarily have to go through the court process if the tenant cooperates, but you do have to go through the city. Then you have to file a declaration, right? That basically says that, hey, this unit was illegal. Okay, the tenant has to move out. I've deposited the money in escrow, however much the tenant owes, and we're going to go into a table that says that, and they have to move out. These other reasons, okay, the government owns the property, it's a residential hotel, it's affordable housing. These are less common. I'm just not going to go into those right now, but they're there. Right now, we're going to go into the JCO. A few things about the JCO. Okay, the Just Cause Ordinance. What it did, essentially, it's kind of like a catch-all. Essentially, what it did is for all the properties that were not covered by the RSO, okay, the Rent Stabilization Ordinance of Los Angeles, now they fall under the JCO. And so the most glaring example of this is you have a home. All right, you have a single family home. Before COVID and before the JCO, in a single family home, as long as you give the notice of exemption, okay, that we mentioned before, you could limit the tenant's occupancy for 1 year. So once the year term was expiring, you could literally tell the tenant, you have to go, even though he did nothing wrong. That, with the JCO, has changed. So now if you're renting a property, even if it's single family property, you cannot just tell a tenant your lease is expiring and therefore you must go. That doesn't exist anymore. Okay, in LA City, for any property, with, of course, specific exceptions, which I'm not going to go into right now, but they do exist. I just want to make that clear. And so those are slightly different than the RSO, but they're mainly the same. They mainly mirror them. The main difference before, okay, obviously you have the owner move in. Obviously you have the residential manager move in. This is the main difference. Okay, the demolition remodel move in. And so for that, you'd have to actually apply for permits first, and then you'd have to show those permits along with the termination notice to the tenant. Okay, but when landlord clients, they come to me and they have a single family home and the tenant has done nothing wrong, he's paid rent, he hasn't committed any violations of the lease. He comes to me and he says, how can I get rid of my tenant? How can I get my tenant out? I say, okay, let's talk about the no fault reasons. And so we go into the no fault reasons, and if he tells me that the owner move-in is not there, he tells me the residential kind of manager is not there, then I say, okay, well, maybe you want to do the demolition remodel move-in, and that usually works. The caveat is that you can't just do this and sell it, all right away. That looks very suspicious. This has to be the type of remodeling that requires a tenant first to move out, and that requires a tenant to move out for at least a month. And it can't be that you manufacture this, right? Like, this has to be extremely reasonable. And the government kind of, has passed laws, to hone down on this, because obviously a lot of landlords, they were kind of being, like, dishonest and disingenuous with these type of things. It needs to be careful with that type of stuff. Of course, the government order to vacate was also in the RSO. The HUD owns and is on the property. I think this mirrors the RSO as well. This mirrors the RSO as well. And this also mirrors the RSO. Oh, when you're talking about the relocation, okay, for no fault evictions, obviously it goes up every year. So you're looking at the top row. This is an eligible household. Okay, this applies to most kind of cases. If the tenant was there for less than 3 years, obviously the 10,000 and change. If the tenant has been there for at least 3 years, obviously you have the 13,000 and change. And then if the tenant is low income, it stays the same. And then if you want to apply for the mom and pop exception, obviously there are specific guidelines for the mom and pop exception. I'm not going to go into those today, but they do exist. So I need to learn those. I need to know what those are. And then the second row is qualified. Now, qualified, there's a few reasons for qualified. It's basically if you're disabled or if you're elderly. I think there are a few other reasons, but those are the main ones. When you're going through this process, you need to go through the city of Los Angeles to do this. And what happens is that they assign what's called a case analyst. And the case analyst will go to another agency and they will interview the tenant and ask them questions to see if the tenant is claiming that they're qualified, if they're elderly or disabled. Then it will go through the process to vet that tenant to make sure that they actually are, if they actually are qualified under the law, right, under the definition of the law. And if you don't agree with that, if you think that they got it wrong, you do have a chance to appeal this. And I've actually been involved in those in those appellate hearings. A few more things that happened post-COVID. The city council that came out with an economic threshold minimum. Essentially what that means is you can no longer evict a tenant in any property unless their accrued rental debt has reached a certain limit. And here are those limits in this chart. And this changes kind of every year, right? Like every year that they have. So for example, this year, efficiency is a studio. That's what they mean by efficiency. But if you have a property that's 1 bedroom, and let's say the rent for that bedroom is $2,000 a month, okay, or whatever reason, and that tenant is behind 1 month, so the total debt is $2,000, you cannot evict them yet. You have to wait until they get to 2081, and you can only evict them if they're higher. Okay, than 2081. And I think that most people are aware of this now, but actually I'm still seeing people that don't know this law. What a lot of tenants do is they'll play with that and they'll stay just under. But what that does is they earn themselves a cushion for that first month. Let's say the first month, they decide to not pay for the 2081. So they're just there. But what happens the next month? They still have to pay at least that amount, to stay under that threshold. So all this wins them, guys. It only wins them basically a month, right? That's all this does. But you still need to be aware of this, right? Because if you come into court and you don't comply with this, this is automatically, the case is going to be out. The case is going to be dismissed most likely. Now, and that's the reason why, in the 3-year notice, you must put the bedroom amount. That's why you put the bedroom amount. Even though you think it's arbitrary, you still need to put the bedroom amount. I have won cases, when I defended tenants, and yes, I also defend tenants, I have to admit. But when I defend tenants, if the landlord does not put the bedroom amount on the 3-year notice, the case will be thrown out. It's not automatic. Obviously, you still have to make a motion to dismiss, but it will be thrown out. Another thing that passed is that if you raise the tenant's rent by more than 10%, obviously you can't do that right now because of price gouging. But before price gouging, before that law, if you raise rent by 10%, and in response to that notice of rent increase, the tenant comes to you and they say, listen, I'm not going to be able to afford this. Now you're looking at a relocation chart of your own. And this is not even a no-fault eviction. This is kind of its own world. You now have to tell the tenant, okay, fine. If you're moving out because of my raise of rent of over 10%, now you owe this tenant, right? Okay, the relocation fees, based on this chart. And this is how they calculate it. They take, the first row, right, which is what they think, is what they think kind of 1 month of rent is going to be. Then they come up with an arbitrary kind of relocation amount, and then they take the moving costs. And the price at the bottom, is what you're going to owe them. So before you consider raising the rent, more than 10%, you need to look at this chart and just kind of think of the cost-benefit analysis. The good thing about it is that if you look on the right of the chart, you see the single-family home, it's 1 month's worth of rent. So it's not going to be $12,000. It's not going to be $11,000. I'm hoping, that at the house that you're renting, right, is going to be under these amounts. Like most kind of houses in LA, they're probably going to rent or less than this amount. And so that's why it helps if you do have a home like that, then maybe the 10%, it may be worth it. It may be worth your while. But right now, because of price gouging, which we're going to get into, it's not even an option. So I do want to go over the next few things kind of just verbally without any slides, because I just want to explain it, because there's a lot to explain here. With the price gouging laws right now, the way that it's working is that, I'm going to stop the sharing so you guys can just see me. With the price gouging, how it's working, essentially, regardless if the tenant is affected by the fire or if the home is affected by a fire, regardless, you're not allowed to right now, with a few exceptions, we're not going to go into those right now, but with a few exceptions, you can't raise the rent by more than 10%. Anything above that, regardless of the other laws that apply, anything about that is going to be considered as gouging, and it comes with penalties. So I highly discourage you guys from doing that because it's illegal. But there are other things that if you were renting a property in the last 12 months and you were charging a certain amount of rent, and that property was vacated before the fires, and let's say now, you want to rent it out a new tenant, and it's post fires, and if the tenants that are coming to you are not victims of the fires, it doesn't matter. You look at what you were renting your unit in the last 12 months, you cannot list the property right now for more than 10% of what you were renting the unit out for in the last 12 months, even though you screwed up and the last tenant you were renting to was under market rate at that time. At this time, I would just hold off. I think right now it's going to be up to March, unless the governor extends that. If he extends it, obviously you have to go with the extension. But right now, I would wait until March to see what happens with the emergency orders. Another thing that a lot of people ask me about is the price gouging thing. I had one landlord ask me, he was renting out a property. He wanted to rent out a property, an expensive property. It was in Beverly Hills. It probably could go for the normal market for about $12,000 a month. And he was asking me, there's a price war, right? There's a bidding war right now. The tenants are coming to me. There's one guy that's offering me $19,000. And he asked me if he could do it. And at first I said, you know what? You're not really initiating the war, right? The bidding war. So at first I thought, it's not really in the law that says you can't entertain a bidding war. At that time, it wasn't really in the law. And at first I told him, you know what, I got to look into it. I couldn't really find a law on point, but I told him to just be cautious about it. I told him, do not do it. Because, this guy could be undercover. This guy could have the intention of going in at 19, but he already has a lawyer that's ready to sue him, okay, at any given point in time. So I told him, don't do it. So basically, essentially, even if you don't start a bidding war, if you have a bidding war that's coming to you, and especially if you have a real estate agent, I know the real estate agent is looking for higher commission, but you tell the real estate agent that, look, I'm only going to accept offers. I'm not even accepting offers. It's not a sale. I'm accepting applicants that are at that price point that I listed it at. I don't want a penny more. So you guys have to be careful about that. Even though you're not initiating bidding war, I would suggest that you take the applicants as they come, right? On the most qualified applicant as they come. And look at credit score, you look at assets, you look at income. Okay, look at the things that you generally look at for tenants. Okay, the last thing that I want to touch on, the suing point that I'm seeing, is these habitability lawsuits. Guys, it's very important to understand that when you're suing an unlawful detainer, right? Okay, when you're suing for eviction, there is no cross complaint available to the tenant. However, what is becoming more popular right now is that these attorneys for the tenants, right, what they're doing is that they understand there's no cross complaint, but there is the ability for a tenant to file a separate lawsuit for habitability, right? Let's say for harassment, whatever, even if there's no base for it. What I'm seeing is that the reason that the landlord's attorneys, the tenant's attorneys are doing it because they know what's going to happen, right? The landlord is going to get the lawsuit and they're going to give it their homeowner's insurance company. And the homeowner's insurance is most likely going to cover defense, right? Okay, with a reservation of rights. Basically, they're going to say that, listen, your policy doesn't cover all these claims, but they still will hire a lawyer to defend you in this lawsuit. And what happens is now your eviction attorney that you hired specifically to do the eviction is now going to say, well, I'm not going to cover this. I'm going to tell you to go to your insurance company. And now insurance company is going to hire an attorney and they're going to have to cover this. And now you're dealing with two lawsuits. Whereas the tenant's attorney could possibly be dealing with like a package where they're going to do both. And so they're not dealing with two lawsuits. I mean, they're dealing with two lawsuits, but really, I don't even think they care about the unlawful detainer anymore, because now what the insurance company is going to tell the unlawful detainer attorney, they're going to say, listen, it's going to be better if you do a global settlement, because the problem is if you go through a trial, all right, whether it's with the judge or with the jury in the unlawful detainer lawsuit, what you're looking at, unfortunately, is if you lose those issues that are tried, right, the habitability issues, the jury finds or the judge finds that there was a habitability issue in the unlawful detainer case, the tenant's attorney in the habitability case that he filed affirmatively can use those rulings against you in his lawsuit, in the affirmative, in the habitability lawsuit. And you don't want that. And the insurance company is weary of that. So they do this because basically the tenant will get out of the unlawful detainer lawsuit and they might get some money on the landlord's insurance company. I know the landlords that are hearing this for the first time are not happy about that, but unfortunately that's how it's going right now. And you shouldn't be surprised if that happens to you guys, but that's why you have insurance. So I guess my small piece of advice to landlords is make sure that the tenant has almost nothing to sue you for. And I know that sounds ridiculous because they're still going to do it. But if a tenant tells you that there's an issue with the roof, fix it ASAP. It's very important. It's not only important for the tenant's health and for the well-being of the property, but for something like this, because at the end of the day, I tell my landlord clients, I said, listen, right? Okay, this is why you have insurance. But also, like, the landlord's telling me, yeah, but I don't want a tenant to my insurance policy because one, my premiums are going to go up, and two, I might be kicked off my policy. And right now with the fires, it's going to be hard to find an insurance policy, that's going to be good. It's going to give you the coverage that you need. It's also going to be premiums that you can afford. I say to that, there's nothing you can do. You need to tender it because the alternative is going to be you're going to have to pay a lawyer for defense. And that could run you who knows how much. And you might lose. And that could run you even more than whatever the premium increases that you're scared of. So I say as a cost-benefit analysis, I would say do give it to your insurance company. Have them take care of it. If you get kicked off because of this, there are policies out there. I'm sure there are going to be policies out there. It's not going to be comfortable. It's not going to be ideal, but that's what's happening. So I think it's just kind of, in my opinion, kind of overview of the things that I've encountered in the last couple of years after COVID. And I think we can open it up, to a Q&A here with Rick. So I can answer a couple questions that you guys may have. But those are the things that I've noticed.
I made a list of questions, but I kept checking them off because you kept answering them.
That's fine.
So, so you did well. A couple questions I had. So regarding the tenant habitability plan, it's really focused on health and safety, right? We're not talking, hey, I'm going to spend 2 months remodeling the kitchen, the bathrooms to make it nicer, right? Is
Correct.
that
Correct. That's not an option for
yeah?
that's not an option
Okay,
for THP, because essentially the habitability plan is if it's necessary.
got
The
it.
whole thing about remodeling the bathroom, that doesn't apply to THP, but it could apply to the no fault eviction, right? Okay, for demolition and
Sure.
remodel. Yeah, just want to make
Got
that.
it. And then for the JCO, it mentions single family. I had a conversation about this with my clients literally this morning, as well as yesterday, on
Yeah,
how the city defines single family. Because there's single family residence, a house, but then there's also condos and townhouses that's technically a single family. So
uh,
would those qualify as well, even if they were built after 1978?
it's not. It's not a single family, right? So
Got
that's
it.
a legal definition, right? Okay, a single family home is a legal definition. Actually, if you look at the assessor, right, the information that the
Hmm.
assessor has, it will define exactly what it is. And so the condo is completely different because you're talking about a condo, you're talking about it's a unit in a different building, right? There's common areas, right? There's
Hmm.
non-common areas. And then a townhome is a type of condo. Okay, a lot of people kind of
Correct.
get those confused. They think they're different things. But even if it's a detached structure, right? Like I've seen it kind of a lot, there's a gated community and you've got these town homes. It sure feels like a single family home, but it is a town home. On the flip side, actually, this is a good point. There are communities that are single family homes, but there is an HOA.
Right. PUDs, planned urban
Exactly.
developments.
Exactly.
Yep.
Right. To pay for beautification, to pay for certain things that are common area, those are still single family homes, even though there's an HOA. So you guys kind of need to understand that distinction.
Nice. Okay.
Yeah.
And then my last question before we end the podcast
Sure.
is what do you see going, like what do you see kind of the future in all this?
Is we got to move to Florida. No. In all honesty, it's becoming more difficult to be a landlord in LA and California. I mean, you see where the politics are headed, right? You
Yeah.
see what happened with the fires. It's a complete mismanagement, and that's all kind of it's part of the same problem. And you have these politicians, right, that are only out for the votes. And then you see kind of what's happening with the voting. You see there's one council member who has to recuse himself because he's a landlord. But the council members that could be tenants are not recusing themselves. So it's not very balanced. But the future looks grim, in my opinion. There's going to be a lot of lawsuits. I think there's going to be a lot of actual lawsuits against the city, against the state for what's happening. And I know that's exactly what happened with the COVID lawsuits. I think there are still some that are still in the pipeline that are going through the Court of Appeals and whatnot. But I think if you still, despite all of this, if you still want to own property, okay, in Los Angeles, then you just have to be more careful with who your tenants are. And it's impossible to screen tenants at the point where 100% they're not going to screw you in the end. It's impossible.
Right.
But you have to mitigate it. So I say you approach the tenant screening process as if you're a bank, okay, you're giving out the loan the same way, right? You look at the credit score, right? Okay, you look at the income, you look at that, and frankly, you profile. And I'm not talking about racially. I want to be very politically correct.
No discrimination.
No discrimination, but you profile and you see, right? Okay, this looks like a nice family, educated people, they're just trying to make a living. As a human being, right? Like you need to interview these people. I had so many people that they go through apartments.com, they go through Zillow. They never even meet these people. And guess what? They're opening themselves up to even fraud. Because I had to deal with an eviction where the person who actually rented the property was not the person on the ID. But the landlord would never know because they never rented it to them. Because they never met them. I say, even if you have a property manager, if you have a property manager, then you need to trust the property manager, first of all. You need to have a
Sure.
rapport with them. And I like the smaller guys more than kind of the bigger companies, because they're kind of easier to talk to. Pay a property manager. Make sure the property manager interviews the tenant face to face, sees their ID, knows who this person is. Because it's very important because you never know. And like I said, there's no guarantee. But you can minimize the risk if you know who you're renting to. If you understand how are they making their money, you know. So what's the reason why they left? Now, what's the reason why they want to move here? If it's for schools, I think you have a good chance. This is a good tenant.
Mm-hmm.
Now, if it's for work, I think you have a good chance. It's a good tenant. That's my piece of advice for that.
Yeah, I will tell you, my clients who've had challenging tenants, one
Yeah.
of the first questions I ask is, were there any red flags in the screening process? And more often than not, they either didn't do enough screening or they made an exception. Oh, especially when it comes to like the price, right? I see that all the time where people are pricing their rentals really high and they're only getting applicants where things are like a little shaky. So then maybe you should drop the price to get a better pool of tenants.
A better pool of tenants.
Yeah.
Yeah, you drop it slightly. I offer kind of screening or landlords because I have access to databases where I can see kind of bankruptcies. I can see all these things. If you guys want, you can call me. I can offer that process. But they're all as part of apartments.com and all these kind of, like other services. They also offer that as well. But
But
here's
not
what I think.
thorough. That was my experience with Zillow. Someone did a Zillow application for me once years ago, and I'm
Yeah.
like, this is not showing me anything, like nothing of
Yeah, Zillow
value.
just wants to close the deal. I mean, they don't really care
Yeah,
as much. So if you came to me, like I have access, like I could see if there are evictions. It's not 100% accurate, right? All these databases
sure.
are, there's kind of as an allowance there, inaccuracies. But I've managed to catch a lot of things, including evictions, including state liens. And I've had landlords that have made exceptions. Like there was a state lien for like $20,000. It was a couple of years ago. Okay, this doesn't mean anything. But that tenant ended up screwing them. And it really just depends on how desperate you are. And I think that your suggestion is a very good one. If you just decrease it by just a little bit, you're going to lose a little bit money, because the rent is now lower, but you're going to get a larger pool of tenants and increase your chances of getting that good ideal kind of model tenant. Another thing that I'm seeing with this is that if a tenant comes to you, and again, this is when you're desperate, a tenant comes to you and say, hey, listen, I know my credit is bad. I'll give you 12 months up front,
I see that all the time.
right, to compensate. As a landlord, you're not allowed to ask for that in the listing. You can't say only 12 months up front, accept it. You can't do that. If you see they have bad credit, you can't say, well, I see you have bad credit, but what if you offer me 12 months up front? I'll take you. You cannot initiate that as a landlord. If they have bad credit, don't take them. But if they come to you and they're saying, listen, I know I have bad credit, but I'm willing to pay you 12 months up front, it sounds like a great deal. Be wary of it, especially with the JCO, because you have a single family home. You're not going to be able to terminate their lease in 12 months. You get the 12 months, you're all happy. Okay, you go invest that money. Great. After 12 months, they stop paying. On month 13, they don't pay. You still now have to deal with an eviction that's eating into the 12 months worth of rent that they paid you. So it's not really 12 months up front. It's 12 months and then a headache. So you still don't, it's a good deal, but take it with a grain of salt. Like still see the tenant, still understand, okay, he has poor credit. How bad is it? Is it in the 400s or is it in the 600s? If it's in the 600s, maybe low 700s, not horrible. Maybe go for it. Also see why his credit was bad. Make him explain it to you. Maybe kind of look at the credit. Okay, so it was bad, because he had this thing or that. Okay, fine. But still see how he makes his money. Still see how he makes his money. It's very important.
Yeah. It's interesting when you brought up the economic thresholds. The first thing that popped in my mind is like, why would any landlord price their rentals below that amount? And like it almost like forces landlords to raise their prices so that way they can keep up with it. Because to your point, if the threshold for a one bedroom is 2,081, you might as well almost like make your rental at least 2,081 or 2,100.
Even though in that particular area of LA City, that is not the market rate.
Right.
So what the city council did by with their actuaries or whatever they use, like whatever kind of math they use to come up with these numbers, they actually screwed everybody because it's making everybody, like you said, have to charge that minimum. And so in those areas where that's higher than the fair market value,
Who
that's what's
cares?
happening there.
Yeah. I noticed that with when they raised the Section 8
Yeah,
numbers.
yeah, yeah.
And I was
Yeah,
like, okay, well, if I'm a landlord, I'm just going to raise my price above that because I know I'm almost guaranteed at least that if I decide to go to Section 8.
yeah.
So it's like, a lot of these laws that are coming into place hurt tenants more than people realize. And economists have done all the studies on this and they all agree.
Yeah.
So yeah, it's super interesting. Well, Leo, thank you so much. Oh, sorry, go for it. You got something. I can see it in your
I
eyes.
see from the Katarina, like one
Oh,
of the participants.
yes, we'll go
It
into
was
those
not a.
after we end. Yeah, after
Oh,
we
I'm
end the
sorry.
podcast.
I
No
thought this was part
worries.
of it. I'm so sorry.
No worries. We will get to those.
Okay.
But Leo, where can people find you if they need your help, have questions?
Here, I can put my stuff up on the screen again. So just so
Yeah,
everybody has it. So there's
perfect.
my information. There's my office number. There's my email.
Yeah, so for anyone listening, it's 818-208-9011, and it's info@rotenberglaw.com. We'll make sure to have all the contact information in the show
Absolutely.
notes as well. So, Leo, thank you so much for being on the show. I really
Absolutely.
appreciate it. We should talk about doing this every few months or so, because I'm sure the
Sure.
laws are changing
I'm sure they're gonna do
tomorrow, right?
Yeah.
So I appreciate it. And thank you all for watching or listening. If you're listening to it, please don't forget to subscribe as well as leave hopefully a great review, but an honest review is always important. And then for all the slides, watch it on the YouTube channel as well. Thank you so much, and I'll talk to you guys soon. Thanks for tuning in to The Key to the City of Angels. I hope you found today's episode helpful as you navigate the world of Los Angeles real estate. Whether you're looking to buy your first home, expand your investment portfolio, or sell in this competitive market, I'm here to help you succeed. Let's connect. Visit my website or follow me on social media to learn more about how I can help you achieve your real estate goals. And if you're ready to take the next step, don't hesitate to reach out. I'd love to work with you. If you've enjoyed this episode, be sure to subscribe, leave a review, and share it with someone who might benefit. Together, let's unlock your potential and make your real estate dreams a reality.